my name is Jane Price, and I'm the director of the Internationally Trained Lawyers Program at the University of Toronto Faculty of Law. And today I'm going to talk about lawyers who come from code-based or hybrid law jurisdictions. So if you come from a non-common law jurisdiction, that is a jurisdiction where the law is based on a code, civil law, Sharia law, some other form of religious law, or a hybrid jurisdiction where the law is based on code partially and common law partially, there may be additional steps you have to take before the NCA allows you to write exams and seek a certificate of qualification. Let's talk first about those of you from hybrid jurisdictions. If you are from a hybrid jurisdiction where your law is based partially on a code and partially on the common law, your first step is to apply to the National Committee on Accreditation. If they recognize your jurisdiction as hybrid, that is partially code-based and partially common law-based, you will likely be eligible for advanced standing under the National Committee on Accreditation and be assigned courses and/or exams, challenge exams, under the NCA in order to complete your accreditation and obtain a certificate of qualification. The NCA will assess your application after you have provided them with your transcripts and the letter from your law society stating that you are of good counsel. And once you get that letter, you will understand what your obligations are. If you're told to write challenge exams, once you complete all of the challenge exams successfully, you will be issued a certificate of qualification and can enter into the licensing process. So that's the case for people who are from hybrid jurisdictions, code and common law. Now I'm going to talk about those of you who come from exclusively code-based jurisdictions. If you come from an exclusively code-based jurisdiction, primarily we think of these as civil or religious-based legal systems, and you are still obliged as an internationally trained lawyer to make contact with the National Committee of Accreditation and ask them to assess your legal credentials. If the National Committee on Accreditation views the jurisdiction from which you come as an exclusively code-based system, they will not be able to grant you advanced standing because they are only able to grant advanced standing and recognize your legal credentials if you come from a common law legal system. So what is one to do if one comes from a civil law or code-based jurisdiction and wishes to become accredited as a lawyer to practice in Canada? There are essentially 4 options available to a code-based lawyer who has emigrated to Canada. The first option is to attend law school in Canada and obtain a JD or LLB degree. After that, you complete the licensure like any Canadian educated law students. The second option is to obtain a JD or an LLB degree, a law degree, outside of Canada from another common law jurisdiction. After that, you have to go through the NCA and then licensure. A third option is to do an LLM, a common law LLM in Canada or in another common law jurisdiction. After you have the LLM, you can then apply to the NCA and see what exams or courses they require you to do in order to complete your certificate of qualification. And of course, once you have succeeded in all of those, you will be able to apply to the Law Society of Upper Canada to obtain a license. Finally, there's a fourth option. You could obtain a license in a common law jurisdiction. For example, you could write the bar in New York, in California, or Australia. And once you have done that and obtained a license to practice law in that jurisdiction, you can then apply to the National Committee of Accreditation for an assessment. And they will assess that you need to write certain exams and or take certain courses. And once you have done that successfully, you will be eligible to enter the licensing process under the Law Society of Upper Canada. So I hope that clarifies things for you if you're from a hybrid or a code-based jurisdiction. Thank you.